Hi, friends, and welcome to The Objective Hindu. In this third part, exploring the Waqf Act and the proposed Waqf Amendment Bill, which is in the Parliament, I want to talk about the key changes that the amendment proposes and how they seek to redress or remedy some of the problems that we've explored in part two of this 3-part video series so far. So before I get into the amendment and the nuts and bolts of what the proposals are, there's one area that I thought we could have spoken about a little bit more in the second video, which we failed to. So I'll just start there, and then we'll move to the amendments per se. So you might remember, if you've looked at the previous video, that I explained the concept of Waqf by user, which was this idea, a very ludicrous idea that if in this case the Muslim community is somehow using a piece of land for whatever purpose, that land can be notified as a Waqf property by the Waqf board. And in fact, I was doing some further research after I recorded the previous one, and I think more than 90% of all the Waqf properties that are registered currently in India. So you might remember there were the 9.7 lakh acres of land and X number of properties. 90% of those are actually Waqf by user, which makes sense because, of course, there's a very small number of properties where someone actually had ownership and then they wrote a deed and then they dedicated it into Waqf for forever. That's the minority, not just the minority. It's a very small number of properties. Most land which is appropriated under the Waqf Act is what would be termed Waqf by user. So those examples that I shared yesterday around the Bangalore Eidgah, etc. So those are really anomalies. Now, what I wanted to briefly talk about today is that in legal parlance, there's a concept of eminent domain. An eminent domain essentially gives the government of the day the ability to acquire any part of land anywhere in India. And so in some ways, the government can always take over some land. And there was a time when the Babri Masjid land was taken over by the central government in the 90s, and the question was whether the government is actually using the eminent domain principle. It so happens that they did not use the eminent domain principle, but one of the parts by which they could have acquired that entire precinct, the Babri Masjid precinct, would have been via eminent domain. So essentially, that's a very powerful mechanism in our current legal setup. But one of the challenges with the existing Waqf Act pre these amendments is that it has an overriding effect on all other laws. And so no one's talked about this, and I don't know the answer to this, to be honest, but I'm kind of asking a very fundamental question. If the Waqf Act today is an overriding law, which it is, which specifically mentions in there that essentially when there's a conflict between this law and any other law, maybe apart from fundamental rights, the Waqf law will prevail. So eminent domain is outside of the Waqf Act, and so all these properties that are Waqf by user, so the mosque, the Bangalore Eidgah case that I explained, or the Taj Mahal for that matter, right, which is essentially what we'd call a public good. It's public property which the government administers on behalf of the nation. If these become Waqf properties, which they have because the Waqf board has the power to notify them as such, the government actually cannot reacquire them even using the eminent domain principle, because the powers of the Waqf Act actually supersede that those of ordinary laws, including eminent domain. So this is a big problem because there is no mechanism, as I understand, via which the government can actually take back something. Forget about an individual, by the way, but even the government can't take back something that has been given to the Waqf unless there is an appeal for which they go to the courts, etc. So I just wanted to touch on this, and let's now move on to the amendments. So there are, I think, 11 or 12 key areas, but we don't need to talk about all of them. There are 6 or 7 important ones, which are really important. So the first one is that the new amendment removes the clause of Waqf by user. So I had explained, the concept that you can have a Waqf nama or a Waqf deed. That's one way to put property into give it into Waqf. The other one was the concept of Waqf by user, which was added in 1995. This amendment seeks to remove that. I had not mentioned there's a third mechanism as well in the existing laws pre these amendments, and that's called Waqf al-Awlad, which was essentially a way in which a Muslim family could, if they want to, circumvent the equal the property laws in India, which give equal share to men and women, to ensure that their property only go to their male child if they choose to. So it was a way to circumvent the secular rules that exist in India to ensure that men and women, or sons and daughters in this case, get equal rights. So that's Waqf al-Awlad. So this amendment now removes Waqf by user and Waqf al-Awlad. The main one is Waqf by user, as I just described. So unless you have a Waqf Nama, and unless you actually own the property and can demonstrate that you cannot give it into Waqf. So then that leads to the logical, so this is a very important and welcome move, but then that leads to the logical question about what about that 90% of existing Waqf land, which is all Waqf by user. When the amendment goes further, in the second section, it talks about the cancellation of all government land which is currently notified as Waqf. Now, they haven't specifically said all Waqf by user, because there might be some legitimate cases as well, as I had described, I think, in the first video. But what this means is that just the fact that something has been notified as a Waqf, and let's say that was public land or government land, like a playground outside a mosque or the Taj Mahal for that matter, all of those are now rescinded. And so neither can there be any future Waqf by user, nor will any existing government/public land that has been usurped by the existing legislations be recognized. So it will have a retrospective effect, and all of those will be removed from the control of the Waqf board. So I think that's these two are, to be honest, the biggest issues that this amendment seeks to address, and I very much welcome them. Just looking through my notes here, so we talked about Waqf by user and government land. Yes, the power to do the survey. So previously there's a survey commissioner that is part of the Waqf board, or the Waqf board appoints them, and so they often choose their own people, etc. And then the survey commissioner then gives the Waqf board the report on the basis of which the Waqf board can decide essentially whatever it wants to. This power has now been removed from the survey commissioners, and the district collector, which is obviously a civic administration post, a senior post, will now be in charge of doing the surveys. So the surveys are now in some ways outside the control of the Waqf board, because they have to go to the collector to order a survey. And of course, the collector does not report into the board, and therefore it's far less likely that they'll be able to to pressurize that person into submitting the sort of report that is favorable to their particular point of view. So that's around the commissioners. It also removes, this is very important, so it also removes the power of the Waqf board to arbitrarily and really unilaterally decide whether a property is a Waqf property. So neither can they do the survey via their own appointed survey commissioners, nor can they then just go back and notify it themselves. This needs to now be done through the district collector, the surveys, and then the actual remember Waqf by user is already gone. So once the survey is done, if a property is to be designated as Waqf property, then you obviously need a Waqf Nama. And then if you have a Waqf Nama, then it can be registered. And that registration will now be done under the sort of traditional land records mechanism that exists in every state. So, the state revenue office or whatever the case might be. So very much curtails the powers of the Waqf board, in addition to obviously removing Waqf by user. The composition of the Central Waqf Committee, which was put in place in the 1995 Act, has also been changed. So it's very interesting. Some people have been talking about the fact that, women could always join that committee. The fact is that there were never any women in that committee. Now the new act mandates that there have to be 2 women on the committee, and it also mandates that there have to be 2 non-Muslims on the committee. And this is a very important move as well, because this idea that only certain members of a certain community can look after the certain members of their own constituency, or so-called constituencies, is a very dangerous idea. And we've seen the where this leads to in the separate electorates pre-partition, and then in Bengal, and then of course the partition of India, which was all, in my opinion, a consequence of this sort of an idea. So the Central Waqf Committee has been reorganized, and 2 women have to be there, and 2 non-Muslims have to be there, which is, I think, a great move. As part of the reorganization of the committee, they've also added some special provisions to include non-Sunni Muslims, specifically the Bohras. So one of the sects of Shia Islam prevalent in Western India, in Gujarat and Maharashtra and Bombay in particular, as well as the Aga Khanis, also sometimes known as the Ismailis. So if the state in which, whatever the state in question might be, if they have Waqf properties that are given into Waqf by either Ismailis or Aga Khanis or Bohras, which is often the case in a state like Maharashtra, then the Maharashtra Waqf Board also needs to have 1 member each of those communities. Previously, the Sunnis could make the decisions on their behalf, which was also not necessarily very representative, because they have different opinions and even some differences in how they perceive the legal implications of a Waqf. So again, this is all about how the Central Waqf Committee has been reorganized. Very importantly, the role of the tribunal. So you remember I talked about the fact that there's a Waqf board and there's a Waqf tribunal where you can go and appeal. So let's say you remember that case of the Tamil Nadu village where I was explaining that there was a gentleman who was trying to sell his land, and he was asked to get a no objection certificate from the Waqf board because apparently the whole village was a Waqf property. Now remember, he had to go to a tribunal. And there was also a limitation on the notification, which I've explained in part 2. So just to remind you, once a notification was previously published, you had to go to the tribunal in 1 year. But the problem was that no one looks at those notifications. And so in many cases, by the time you realize that there was something to fight for, the 1 year has passed. So two major changes have happened. Firstly, the tribunal itself, the composition has changed, and the Qazi, or the sort of Muslim cleric who was a key member of the tribunal and often the key decision maker, that has been removed. And the tribunal will now only be composed of essentially of bureaucrats, of both civic administrators and people from the judiciary. So that's again a very welcome move. The other thing it removes is the limitation on going to the court. So one thing I had not fully mentioned in the second video is that originally, as part of the 1995 law, the decision of the tribunal was binding, which means you actually could not go to court. Later, the High Court, I can't remember which of the many High Courts in India, but a particular High Court essentially changed that suo motu and said that that you can always come to us, and that the High Court can always intervene if it chooses to. So in some ways, even though the Act did not permit it, by precedent, the doors opened up for someone to go to the High Court after the tribunal has ruled. So it was still not ideal, but at least you could go to the High Court. But remember, this happened because the High Court essentially invited themselves into the conversation. But the problem was this whole limitation deal, right? So now the tribunal's composition has changed. The cleric is gone, and after the ruling of a tribunal, the party, whoever's contesting, has 90 days to go to the High Court. So now this is part of the law rather than as a precedent that the High Court had introduced. Now officially, from once you've got the decision from the tribunal, you can go and appeal into the High Court. And of course, the tribunal now is far more secular than it used to be. So it's almost like a civic court. It's still a parallel court, but it's similar to a civic court. So I think those are some of the biggest amendments. Like I said, there are a few others, but I think these are the biggest sort of topics. And just to recap, the fact that Waqf by user has been cancelled, Waqf al-Aulad, the removal of all existing government and public properties from the Waqf register, removing of limitations in terms of whether you can go to the court, etc. These are all welcome moves. The reorganization of the committee. There are a couple of things that I would have really liked to see, which I maybe they'll add them after the Joint Parliamentary Committee report is finalized. But I would have actually loved to see any non-Muslim involved in these excluded from the entire Waqf mechanism. So if there's a property dispute and one party is Muslim and the other party is non-Muslim, then the non-Muslim party should have the right, in my opinion, to say that I do not wish to discuss any of this with the Waqf tribunal. I just want to go to a regular court. Now, I can see why they haven't done that, because they've really turned the Waqf tribunal into some kind of a civic court specifically for Waqf properties. So it's a step in the right direction. Although I wonder what prevented them from just saying that this only applies to Muslims, and as soon as there's a non-Muslim involved, you can just go down the standard sort of path. So that would be one thing that's perhaps missing. And then I'm very interested in seeing how will they actually go ahead and define which of the millions of properties today that are designated as Waqf properties are what the amendment calls government land, and how will the government essentially argue, because of course the Waqf boards and the other parties are all going to go to court as well on these topics. So how will the government argue that this is government land? I suspect what they'll need to do is to say that unless you have a Waqfnama or a Waqf deed, you simply don't have a case. So then that might mean that any property that was historically Waqf by user, the government can go and claim. I suspect what the government will do is obviously not go and try and claim the properties that are what I had called in the first video legitimate Waqf by user. So let's say there's a graveyard, and that graveyard is also technically public land, or it's government land. Perhaps the government will say, you know what, you can keep the graveyard and administer it, because that makes sense for you to do. We'll not take that back, even though there's no Waqfnama. But that's, like I said, a legitimate Waqf by user case. But I think the government will essentially, as a result of this, reserve the right to take anything back, should they choose to, in the absence of a proper Waqf deed. So I think it returns a lot of the power to the government. And if you remember this whole eminent domain idea, which I was mentioning at the start, that currently I don't think the government actually even enjoys eminent domain. In some ways, the government now is empowering itself to be in a position where it can always decide, eminent domain in some ways, directly or indirectly. So I think, again, that is welcome, and we'll see how these shape up. There's a lot of noise about this already in the media, and the usual suspects are all on the streets because Islam is in danger. As soon as you hear Islam is in danger, you know that you're on the right track, by the way, because that's the fear mongering tactic that will be used. I was looking at some of the briefing notes from the Joint Parliamentary Committee hearings, and it was very nice to see that some delegations of the Pasmanda Muslims, the so-called backward Muslims of India, they have actually welcomed most of these changes, because they have never benefited from any of this. But of course, the leadership of the in quotes Muslim leadership of India, your Owaisis, etc., they all tend to be from the sort of the upper strata of Muslim society, and they are the ones who tend to enjoy a lot of the power, and they are the ones who are now very concerned, because their ability to have a free run at whatever they want to is clearly under threat thanks to these amendments. So hopefully you found these 3 videos helpful, and if you did, please feel free to share them with anyone might be interested. If you have questions, please feel free to ask me via the comments, and I'll try and respond to them. But thanks for joining. Appreciate your time.